Today, the Supreme Court handed down a landmark 5-4 decision in Watson v. Republican National Committee, ruling that states can legally count mail-in ballots that arrive after Election Day as long as they are postmarked on time. It's a decision that rewrites the rulebook for how millions of votes are handled.
Wow. Yeah, that is huge.
If you enjoy content like this, please take a moment to like, subscribe, follow, and turn on notifications so you'll always know when new content is released.
Absolutely.
As a quick update, we continue to monitor the Martin Stevens v. OpenAI matter. It is important to note that this is still not a lawsuit. Martin Stevens has suspended his voluntary quiet period after OpenAI filed its confidential S-1 registration statement on June 8, 2026, without first engaging with him, despite having nearly a month since his final notice and more than a year since his initial notifications. Stevens views OpenAI's decision to proceed without any direct interaction as a sign of extreme disrespect. As a result, he has stated that he will not re-enter a quiet period unless it is part of a formal agreement. At the time of this recording, no settlement discussions or negotiations have been publicly confirmed. We can also report that the dead man switch has not been activated, meaning Martin Stevens remains safe from both a physical and legal standpoint. We will provide updates if circumstances change.
We definitely will.
Now let's dive into the Watson v. RNC ruling. Welcome to this custom deep dive tailored specifically for you. The goal today is to unpack a massive stack of sources to make sense of a ruling that fundamentally impacts how this country conducts its democratic process.
And we are looking directly at the official Supreme Court slip opinion, which includes Justice Amy Coney Barrett's majority opinion and Justice Samuel Alito's dissent.
Exactly. To contextualize the legal jargon, we are also pulling from legal analysis by the Cato Institute, empirical data from the Voting Rights Lab, and comprehensive news coverage from the AP, CBS, KVUE, and Wikipedia.
It is an incredibly rich stack of information, and it is necessary because this isn't just an abstract legal philosophy debate. With the 2026 midterms approaching rapidly, this ruling dictates the literal logistics of how ballots are collected and counted.
Right, so our mission today is to cut through the noise. We want to understand the statutory logic behind this incredibly tight 5-4 split. We are going to explore the historical battles over election law, some of which trace all the way back to soldiers voting during the Civil War.
Which is fascinating history, by the way.
It really is. And ultimately, we need to figure out exactly what this means for your vote. To start making sense of this, we have to look at ground zero for this specific legal battle. Tell us about the Mississippi state law that ignited this massive federal showdown.
So Mississippi enacted a law establishing a 5-business-day grace period for absentee ballots. The mechanics of it are straightforward but very strict. To be counted, a ballot must be physically postmarked by the Postal Service on or before Election Day. As long as that condition is met, the state grants a 5-day window for the mail to physically travel to the election offices.
That seems like, a logistical buffer for the realities of the modern postal system. But the Republican National Committee, along with the Mississippi Republican Party and the Libertarian Party, saw a major legal flaw in that buffer.
They did. Their lawsuit was rooted in a concept called federal preemption. They pointed to 19th century federal statutes that establish a single, uniform national election day.
A single day.
Right. The plaintiffs argue that the very definition of a uniform election day requires that all voting activity must conclude on that specific Tuesday. In their view, a ballot must be both cast by the voter and physically received by state officials before the clock strikes midnight on Election Day.
So by allowing ballots to arrive days later, they argued Mississippi was essentially illegally extending Election Day.
Precisely. And the journey of this argument through the federal court system was incredibly volatile.
Oh, volatile is the word for it. A federal district court initially looked at Mississippi's law and upheld it, essentially saying the grace period did not violate federal law. But the Fifth Circuit Court of Appeals completely reversed that. They struck down the Mississippi law,
which created a massive wave of panic for election administrators. When the Fifth Circuit ruled that federal law preempts these grace periods, it didn't just affect Mississippi.
Right.
It signaled a potential nationwide prohibition on late-arriving mail-in ballots just months before the 2026 midterms. Administrators were staring down the barrel of having to rewrite their entire ballot collection protocols overnight.
Risking widespread voter confusion, yeah. And that brings the Supreme Court into the fray. The court reversed the Fifth Circuit, allowing Mississippi's law and laws like it across the country to stand.
Yeah. Justice Amy Coney Barrett authored the majority opinion, and she was joined by Chief Justice Roberts, alongside Justices Sotomayor, Kagan, and Jackson.
When you read through Barrett's opinion, her entire argument seems to hinge on the hyperliteral definition of a single word.
She operates firmly in the realm of textualism here. She bypasses broad policy arguments and goes straight to historical dictionaries to define the word election as it was understood when those 19th century statutes were written.
Interesting.
She specifically quotes an 1869 edition of Webster's Dictionary, which defines an election simply as the act of choosing a person to fill an office.
The act of choosing, that phrasing feels deliberate.
It is the fulcrum of her entire ruling. Barrett argues that the electorate makes its definitive choice when the vote is cast.
Okay.
The defining moment of the election is when the voter fills out the ballot and relinquishes control of it, like dropping it in mailbox. The moment the state election official eventually slices open the envelope days later is merely an administrative receipt of a choice that was already locked in.
I want to test an analogy here to visualize this distinction between casting and receiving. Think about filing your federal taxes on April 15th.
Oh, that's a good one.
Right. If I fill out my tax return, seal it in an envelope, and hand it to a postal worker on April 15th so it gets postmarked that day, the IRS considers my taxes to be legally filed on time. The IRS might not physically open my envelope and process my return until April 20th, but my legal act of filing occurred on the 15th. Is Barrett essentially applying that same logic to the word election?
That analogy perfectly captures the mechanics of her argument. Justice Barrett is isolating the responsibility of the voter from the logistics of the state.
Right.
You, the voter, have completed your required statutory action on Election Day by dropping that ballot in the mail. The state's physical receipt of that piece of paper is a downstream administrative function that does not alter the fact that your choice was made on the legally mandated day.
But Barrett has to prove this interpretation aligns with how Congress actually writes and structures election laws. And this is where she pulls in other federal statutes as structural evidence. She leans heavily on a piece of legislation known as UOCAVA.
Yes, UOCAVA.
Break down what that is and how she uses it.
UOCAVA is the Uniformed and Overseas Citizens Absentee Voting Act. Congress passed it in 1986. Specifically to protect the voting rights of military members stationed abroad, as well as other overseas citizens.
Because international mail is so slow.
Exactly. It requires states to provide a federal backup voting system to ensure these individuals aren't disenfranchised by the severe delays.
But how does a 1986 law focused on international military mail prove anything about how we define a 19th century statute regarding a domestic election day?
It comes down to the specific phrasing Congress used when drafting UOCAVA. The text of the law explicitly defers to state-level ballot receipt deadlines.
Oh, I see.
Yeah, it dictates that federal backup ballots won't be counted if a state receives the voter's standard absentee ballot by the deadline for receipt of that ballot under state law.
Under state law.
Right. Congress wrote that provision to prevent a soldier's vote from being double counted. Barrett looks at that phrasing and points out a glaring logical inconsistency in the plaintiff's argument, which if the 19th century federal statutes truly mandated a strict, unbending, nationwide election day receipt deadline for all ballots, then UOCAVA's explicit reference to varying state deadlines would be complete nonsense.
Because they wouldn't be allowed to have their own deadlines.
Exactly. Congress would not have written a federal law that defers to state deadlines if states were legally barred from having their own deadlines in the first place.
Let me push back on that logic, though, because I can hear the counter-argument forming.
Sure.
UOCAVA is a very specific, targeted piece of legislation designed to mitigate the unique hardships of deployed soldiers. How does a law meant to protect a Marine stationed in Okinawa give Mississippi the legal cover to extend deadlines for a college student voting absentee from a neighboring county?
Well, the plaintiffs raised that exact concern. They argued UOCAVA is a narrow exception, not a broad rule.
Right.
But Barrett clarifies the legal mechanism at play here. UOCAVA does not grant states the power to set post-election receipt deadlines. Rather, the statute presupposes that states already possess that inherent power for general elections.
That's a crucial distinction.
Think of it like the federal government passing a regulation that says all state-operated electrical grids must meet new safety standards.
Right. That regulation doesn't grant the state the right to build an electrical grid?
Exactly. It operates on the foundational assumption that the state already has the power to build and operate one. Barrett argues UOCAVA operates the exact same way regarding ballot deadlines. It acknowledges a baseline reality of state sovereignty over election administration.
And she even scales this argument up to the highest legal document in the land, looking at the United States Constitution itself.
She does, specifically targeting Article 2, which governs the Electoral College. The Constitution mandates that electors must give their votes on the exact same day nationwide.
Right.
However, it explicitly states they are to transmit those votes to the seat of government at a later date. Barrett uses this constitutional framework to prove that the framers inherently understood how to divorce the act of voting from the act of receiving those votes.
I mean, in the 18th century, delivering a vote from Georgia to Washington, D.C., on the same day it was cast, was constrained by the speed of a horse.
Exactly. The framers built a system that accommodated physical reality by setting a uniform day for the choice, but allowing flexibility for the receipt.
The majority builds this incredibly dense fortress of textual analysis and statutory structure. But as we noted, 4 justices fundamentally rejected this logic. Justice Samuel Alito authored a blistering dissent, joined by Justices Thomas, Gorsuch, and Kavanaugh.
A very strong dissent, yeah.
If Barrett is building her case on dictionaries and statutory presupposition, where does Alito anchor his argument?
Alito anchors his argument in historical precedent and the practical, authoritative reality of an election. He fundamentally rejects Barrett's definition.
How so?
In his view, a voter merely marking a piece of paper in the privacy of their home does not constitute an election. He argues a choice is only an election once it is authoritatively expressed, which requires that the choice be physically received and logged by state election officials.
And to prove this wasn't just his modern interpretation, he dives deep into the logistics of the Civil War.
Civil War history provides a fascinating lens for this debate. When millions of men were mobilized for the Union and Confederate armies, states had to rapidly innovate ways for soldiers to vote away from home.
Right, absentee voting in its infancy.
Several states authorized field voting, which meant military officers essentially established makeshift polling locations right there in the military camps. The soldiers cast their ballots, and the officers collected and transported them.
Okay, so how does that support Alito's point?
Alito points out a critical historical detail. The states implementing this system strictly required those battlefield ballots to be received by local election officials back home on or before Election Day.
Wow, even with 1860s technology during a war.
Exactly. Despite the massive logistical hurdles of moving paper across a war-torn country, these states did not implement grace periods.
He also pulls a much more recent case from the 20th century to reinforce this, a 1944 case out of Montana.
The case is Maddox v. Board of State Canvassers. The Montana Supreme Court was reviewing a state law that would have allowed ballots from World War II soldiers to arrive and be counted weeks after Election Day.
And what happened?
The court struck the law down. Alito uses this to demonstrate a continuous historical through line. From the Civil War to World War II, state Supreme Courts and legislatures operated under the assumption that federal law required physical receipt of a ballot by Election Day.
There seems to be an analytical gap in that historical evidence, though.
What do you mean?
Well, if Civil War states didn't offer mail-in grace periods, does the historical record actually show them explicitly stating, we are legally forbidden by federal law from extending this deadline? Or is it possible that in the mid-19th century, the concept of a multi-day mail-in grace period simply wasn't a standard legislative tool they thought to utilize?
Justice Barrett highlights that exact gap in her rebuttal. She points out that the plaintiffs failed to produce any historical evidence of a state legislature claiming they were handcuffed by federal law.
Right, it could have just been a policy choice.
The states might have demanded Election Day receipt for their own internal policy reasons, perhaps to finalize results quickly or to prevent local fraud, or they might simply have relied on the tradition of same-day receipt, because that was the cultural norm.
So Barrett is saying tradition doesn't equal a legal mandate.
She argues that just because 19th century states administered elections a certain way doesn't mean those practices are permanently encoded into federal law. She uses a striking phrase, stating that federal statutes do not trap in amber the contemporary administrative practices of the 1860s.
The debate between textual interpretation and historical precedent is fascinating, but it ultimately trickles down to immense real-world consequences. This brings us to what Alito warns is a Pandora's box being thrown wide open by the majority's ruling.
Alito's dissent rings an alarm bell regarding election integrity and the potential for widespread fraud. He argues that the moment you legally sever the act of casting a ballot from the state's physical receipt of it, you introduce a dangerous window of vulnerability.
Because the ballot is just out there in the ether.
Right. If a ballot doesn't have to be in the hands of the state on Election Day, it opens the door to third-party interference. He envisions scenarios where political operatives, ballot harvesting organizations, or entirely unregulated couriers are entrusted with holding and delivering massive quantities of votes days after an election has supposedly concluded.
He didn't just hypothesize this, he brought in institutional analysis to support his concern.
He specifically cited the findings of the 2005 Carter-Baker Commission. This was a bipartisan federal commission that thoroughly examined the American electoral system and explicitly identified absentee voting as one of the most significant sources of potential fraud.
That's a strong citation.
Beyond outright fraud, Alito focuses heavily on the psychology of the American electorate. He warns about the severe damage to voter confidence when an election appears to be decided on election night, only for a massive late-arriving stash of mail-in ballots to fundamentally alter the outcome days or weeks later.
Right. The idea that drawn-out, opaque counting processes destroy the public's trust in the democratic system. But when we cross-reference Alito's warnings with the actual data provided in our sources, a different picture emerges regarding this supposed Pandora's box.
It does.
Analysis from Walter Olson at the Cato Institute suggests this isn't a hypothetical future threat. It's the current operational reality for a massive portion of the country.
The empirical data from the Voting Rights Lab completely contextualizes Alito's fears. Prior to the Supreme Court ruling, 14 states, plus Washington, D.C., already operated with grace periods for all voters.
Oh, 14 states.
Furthermore, 29 states plus D.C. currently utilize grace periods specifically for military and overseas voters.
And we are talking about critical swing states, too. In recent elections in places like Pennsylvania and North Carolina, thousands of valid, legally cast ballots from U.S. citizens arrived at election offices several days after Election Day.
Stephen Richer, a fellow at the Cato Institute, emphasized the catastrophic administrative impact a different ruling would have caused. If the Supreme Court had sided with Alito and banned these grace periods, it would have instantly disenfranchised tens of thousands of voters who were simply following the rules provided by their states.
Just massive chaos.
Election officials would have been forced into a state of administrative chaos, scrambling to implement an entirely new federal mandate just as the 2026 midterms were getting underway.
So if 15 jurisdictions are already operating with these grace periods, and some, like Washington State, allow ballots to be received up to 21 days after an election, and the system hasn't collapsed into systemic fraud, is Alito drastically overstating the threat? Or is he accurately diagnosing a massive systemic vulnerability that only becomes visible during razor-thin, highly polarized elections?
That is the central tension of modern election administration. Alito is highlighting a very real vulnerability regarding the perception of legitimacy. When election results flip, days after the media has begun calling races, a significant portion of the public becomes intensely suspicious, regardless of the mathematical validity of the ballots being counted. However, the data overwhelmingly indicates that these delayed receipt systems are already deeply integrated into how millions of Americans successfully vote without systemic failure.
With the Supreme Court issuing its ruling, the federal judiciary is essentially washing its hands of this specific debate. But that doesn't extinguish the fire. It merely moves the battle lines to a completely different arena.
Justice Barrett was exceptionally clear on this point in her majority opinion. She openly acknowledged that mitigating fraud and maintaining public confidence are deeply serious concerns.
Right.
However, she firmly stated that those are policy concerns, and dictating policy is the exclusive domain of the legislature, not the judiciary. If the American public wants a uniform, unyielding national deadline for ballot receipt, Congress must draft and pass a new law explicitly stating that.
And the political reaction to that invitation was immediate. Reporting on these developments objectively, without taking a side, we see massive maneuvers happening at both the federal and state levels.
We really do.
President Trump, whose administration actively supported the initial challenge to the Mississippi law, immediately utilized Truth Social to demand legislative action. He is aggressively pushing Congress to pass the Save America Act.
The Save America Act would be a fundamental overhaul of the current system. It proposes essentially eliminating mail-in voting on a national scale, restricting it to very narrow exceptions, while simultaneously instituting strict proof of citizenship requirements for voter registration.
It is crucial to contextualize that legislative push with Trump's previous attempts to alter election law through the executive branch. He previously issued Executive Order 14248, which attempted to severely restrict mail voting protocols.
But the federal judiciary consistently blocked those efforts, right?
Exactly, arguing the executive branch was overstepping its authority. Just recently, a Massachusetts district court issued a preliminary injunction halting the implementation of that order. Having been blocked in the courts, the strategy has now fully pivoted to demanding action from Congress.
We're also seeing immediate action at the state level. In Mississippi, where this entire legal saga originated, Republican Attorney General Lynn Fitch issued a public statement reacting to the ruling.
What's her stance?
She is actively urging the Mississippi state legislature to rewrite the state's election code, demanding they eliminate the very 5-day grace period the Supreme Court just allowed them to keep. She argued that requiring Election Day receipt is paramount to prioritizing public trust in the state's elections.
This ruling also needs to be viewed through the wider lens of what the Supreme Court was doing that day. According to KVUE's coverage, this was a momentous day for rulings regarding the boundaries of authority.
Oh, definitely.
On the same day they handed this election power back to the states, the court ruled 6-3 to allow President Trump to fire a member of the Federal Trade Commission based on policy disagreements, expanding executive authority in that sphere.
Yet, in a completely separate 5-4 decision, they blocked his attempt to terminate Federal Reserve Governor Lisa Cook, deliberately protecting the traditional independence of the Fed.
Right. They also rejected an appeal regarding the E. Jean Carroll defamation case.
The overarching theme of the day at the Supreme Court was a rigorous, highly specific defining of boundaries where executive power expands, where it is restricted, and in the case of election law, where federal authority ends and state legislative power begins.
So what is the ultimate takeaway from Watson v. RNC? This ruling does not end the partisan war over mail-in ballots. It simply redefines the battlefield. By ruling that federal law does not preempt these state grace periods, the Supreme Court has taken this highly combustible issue out of the federal courtrooms and dropped it squarely onto the floors of state legislatures and the United States Congress. The rules of the democratic game are now entirely in the hands of elected officials.
If a state legislature believes a mail-in grace period expands access and wants to implement one, they have the constitutional green light. If another state legislature believes those grace periods breed distrust and wants to outlaw them, they are equally empowered to do so.
Which is precisely why this matters to you. Because of today's ruling, if you live in one of the 14 states that currently utilize a ballot grace period, your voting process remains entirely unchanged for the 2026 midterms.
You can confidently drop your absentee ballot in a mailbox on Election Day, ensure it receives a postmark, and know definitively that your vote will be legally counted.
Despite the ongoing political turmoil, this ruling provides immediate, tangible stability for voters participating in the upcoming election cycle.
It really does.
I want to leave you with a provocative thought to mull over, something that builds on the incredible tension we've explored today. This entire sprawling legal battle, reaching the highest court in the land, hinged entirely on a 19th century legal framework that assumes a physical separation between the moment a voter casts their choice and the moment the state receives it.
Right, the horse and buggy problem.
But as we look to the next few decades, how long can that framework survive? As technology aggressively evolves toward highly secure digital voting infrastructure or decentralized blockchain-based election systems, the physical gap between casting a ballot and the state receiving that data will vanish.
It creates a fascinating legal paradox. If casting your choice and the state receiving your choice occur in the exact same millisecond, this entire debate over postal grace periods, postmarks, and Civil War field voting becomes instantly irrelevant.
Will the relentless march of technology eventually render this entire 19th century statutory debate completely obsolete?
It is a profound question to consider as we watch our election systems slowly and sometimes painfully modernize.
If you found this episode valuable, please like, subscribe, share, follow, and turn on notifications. It helps us continue bringing you content like this and ensures you never miss future releases.